Two cases that show justice is difficult to obtain when the state holds all the cards in terms of legal staff and financial resources. Were political considerations behind separate decisions by a state district judge to prohibit a contractor from seeking public records, or a Second Circuit Court of Appeal judge to overturn a $20 million judgment against the Louisiana Department of Transportation and Development? While definitive answers are difficult, there does seem to be sufficient reason to suspect that the lines between the judicial and administrative branches of government may have been blurred by the Second Circuit Chief Judge's decision to negate the award of a contractor who a 12-person jury unanimously decided had been put out of business because he refused to acquiesce to attempts of bribery, extortion, and conspiracy. Judge Henry N. Brown, by assigning the case to himself and then writing the decision despite the fact that his father had been a DOTD civil engineer for more than 40 years, may have placed federal funding for Louisiana highway projects in jeopardy. And the ruling by a 14th Judicial District Judge, David A. Ritchie, prohibiting Breaux Bridge contractor Billy Broussard from making legitimate public record requests of the Calcasieu Parish Police Jury or of the Calcasieu Parish Gravity Drainage District 8 would appear to be patently unconstitutional based solely on the state statute that gives any citizen of Louisiana the unfettered right to make public record requests of any public agency. In Broussard's case, he was contracted by Gravity Drainage District 8 to clean debris from Indian Bayou following Hurricane Rita in 2005. Work done by his company was to be paid by FEMA. Gravity Drainage District 8 instructed Broussard to also remove pre-storm debris from the bottom of the bayou, telling him that FEMA would pay for all of his work. FEMA, however, refused to pay for the pre-storm cleanup, and Gravity Drainage District 8 subsequently refused to pony up the money. Broussard, represented then by attorney Jeff Landry, since elected Attorney General, filed a lien against the drainage district. When Broussard lost his case before Judge Ritchie, he continued to pursue his claim and submitted this public record request to the drainage district and the police jury. Those efforts resulted in a heavy-handed letter from attorney Russell J. Stutes, Jr., which threatened Broussard with jail time if he persisted in his harassment of Calcasieu public officials. And the injunction barring Broussard from future record requests, instead of being filed as a separate court document, was sought under the original lawsuit by Broussard, which presumably, if Stutes' own letter is to be believed, was final and thus closed case, assuring that Broussard would be brought back before the original judge, i.e., David Ritchie. That was such a blatant maneuver that it left no lingering doubts that the cards were stacked against Broussard from the get-go. Everything was tied up in a neat little package with a pretty little bow attached, and Broussard was left holding a $2 million bag and assessed court costs of $60,000 to boot. In Jeff Mercer's case, federal statute U.S. Title 49 specifically prohibits discrimination against disadvantaged business enterprises. It further requires that all states receive federal funding for transportation projects must have a DBE program. Mercer, a Magnan contractor, sued DOTD for claiming that DOTD withheld more than $11 million owed to him after he rebuffed shakedown efforts from a DOTD inspector who demanded that Mercer put some green in his hand and then he could make things difficult for him. Mercer suffers from epilepsy, which qualified him for protection from discrimination under Title 49. His attorney, David Daughtry of Rayville, feels that Brown should never have assigned the case to himself, nor should he have been the one to write the opinion. Needless to say, Daughtry does not agree with his decision. He has filed an application for a rehearing in the hopes of having Brown removed from the case. Louisiana Voice conducted a search for this list of cases reversed by the Second Circuit, and the Mercer case was the only one of 57 reversals decided by a jury. So it all boils down to a simple equation. How much justice can you afford? When an average citizen like Broussard or Mercer goes up against the system, things can be overwhelming, and they can get that way in a hurry. Because the government, be it DOTD represented by the Louisiana Attorney General's Office or local Gravity Drainage District represented by the District Attorney, has a decided advantage in terms of manpower and financial resources, giving the individual little realistic chance of prevailing. In Broussard's case, he did not. Mercer at least won at the trial court level, but the process can wear anyone down, and that's just what the state relied upon when it appealed.